2877, the applicants of Radnor Fire Company. We have a letter from them asking for a continuance. Is there Mr. Couchet?
Good evening, members of the board. Nicholas Couchet here on behalf of Radnor Fire Company and Metro PCS. We did, by letter, request for a continuance until the January meeting. As the board is well aware, we are in the midst of our due diligence to research all alternative sites to the proposed site. It is a long process for both parties. Again, we are hopeful that over the next couple of months we will have that review buttoned up, and we'll either be meeting before the board, before the township, to review the findings, or submitting a different application for a different location.
Okay. A couple of things, Mr. Couchet.
Yes, sir.
It's always been the policy of this board to limit the amount of times the continuances are issued. This specific case has been going on for quite an extended period of time. There's a couple issues that I personally have, and the board can add to it or subtract from it. I think that this would be the last extension that I personally could vote to grant. Are you sure that the January is a good date? Do you think you might want to come and make it extended a little bit longer? That's your decision. It doesn't make any difference to me, and I'm sure the board. And when you come back in January or February, whichever one you decide to ask for, I think it would be my deference that you present your case either one way or the other, or withdraw it without any prejudice and go from there. I just think that it's gone so long. Also, we would request that you at least 2 weeks prior to give us a synopsis of what's going on, so we can, we can kind of refresh our own minds, because it's really been a long time. At least that's how I look at it. Anyone want to add to that, or anything that I may have missed? Or
I mean, in general, one of the problems is the record goes stale, and the facts can change. I mean, people who objected could have moved, new people could live there.
Certainly.
1,000 other things could have happened, plus we don't remember anything that's in that transcript, and we're going to have to review it. So, if you're going to come back in January or come back in February, we're going to want some warning. We're going to want you to file the plans that comply with the issues we raised last time. In the meantime, we will have that warning, so we were going to review the transcript from before, so we'll know what we're looking for again.
Absolutely.
We've had a lot of cases go over the dam and under the bridge since then.
Understood, and I agree completely.
Yeah, just to clarify, I think what I would like to see, and the board can, stop me if they disagree, is a 2-week warning that you are going to proceed with the case. And I'd like to also have submitted, just as if it was an initial application, I think it's 10 copies of any exhibits or memoranda of law or whatever you have that could be then reviewed by the board. We have access to the transcript from the other hearing, but we would like to see if there are going to be new plans, if there's going to be new whatever they are, to have them into the township 2 weeks before the hearing date so that we can review them. Have I got that right?
Need the transcript? I mean, do you have extensive notes on? Do you remember exactly what it is we're requiring? And
oh, I do. In fact, I was reviewing yesterday. I have a copy of the transcript, and I was reviewing the end of our last meeting.
It's just been a long time.
Understood completely.
It's gotten stale to not only us, but to anyone else in the township that may,
certainly,
be for or against your hearing. And again, you may get it resolved, and it may not be necessary. But I think it's the board's position that this will be the last continuance, and if it comes up later on, you're just going to have to refile and start over again.
Understood.
Okay.
Understood. I will let my client know. I will say.
Do you want to continue on January, or do you think that maybe you might need till February, because this is you're not going to get one if it's
right.
Pick January. You can't come in January and say, I should have taken February.
Well, keeping in mind that I think April may very well be 1 year since the first hearing, or close to it.
It may very well be.
So, let's not push it too far.
And of course, if you keep it till February and you figure you got it done in January, you come in January. If you get it, you know what I mean?
Understood. I believe, Mr. Chairman, I will keep it for January. That's what I'm authorized by the client at this time. So I will keep the January date, duly noting all of your comments. And if we were to require an additional continuance, we would then have to withdraw with prejudice.
Yes.
Understood.
Or come in January and present your case and
Yes.
then go up or down on the vote.
With the 2-week
But
notice.
if you
and-
do
and
come in,
submission.
if you do wish to present your case, we need a warning by the 3rd of January that you wish to do that, and also copies by the 3rd of January of, 10 copies of all the exhibits, any memos of law, whatever it's going to be, so that we can circulate those and get familiar with the case again.
That's not a problem, Mr. Ryan.
Is continued hearing going to be advertised in any way? Do we require an advertisement?
I
Does
think
not
it just
require
goes
an
out in the letter,
advertisement.
right, like it normally does, or in the
does.
paper. How do you normally do that, Kevin?
I mean,
We
how
do-
will the neighbors, for instance, know that this is going to be heard?
What you see in front of you is what we advertise in the paper. We don't reiterate the entire description over and over, just that it was continued from the previous month, whenever it was continued
So there
from.
will be a notice. And those notices don't go out like the original ones do to everyone within a radius?
No, we do not re-notify the residents within 1,000 feet or 500, if that's the case.
Not that I'm looking to make trouble for you, Nick.
No,
I
understood.
I want to be fair to everybody who has an
Of
interest.
course, and I appreciate it.
Okay?
Yes.
Okay. Is everyone okay with the continuance till January 17th meeting?
Yes.
Yeah, subject to the condition you mentioned,
Yes.
yes.
Okay.
And you do
Peter?
extend the time on the, for the hearing until the 17th, and also the, 45 days running from the closure of hearings.
As noted in our letter, yes, Mr. Ryan, we do.
Okay. Mr. Cachet, you understand the board's position. The 17th will be either you continue it, withdraw it, or, it's going to get heard.
Understood.
Very good. Thank you. Have a
Thank you
great
all very
holiday.
much. Have a good evening.
We're going to jump over appeal, we don't have to do that. Appeal 2884 and go to 2885, if that's okay, only because 2884 and 2886 are the same thing, so we can probably do both of them at the same time. Okay. Okay, thank you. Appeal 2884, applicant 615 Newtown Road Associates LP. Nope, that's the wrong one.
Oh, no.
Of applicant Eric and Christine Quisenberry with a property located at 6 Rodney Road and zoned R4. Residential seeks a variance from section 28030D1 and 28030E to construct an addition or any other relief necessary for the code.
Thank you.
Cornelia, I haven't
Good
seen you in a
evening.
while.
I know.
What's
Good evening.
happening?
We need a better economy. No one's
Is that
building
what it
anything
is?
on homes. It's all about the economy.
So you bring us
I'm
an
not
easy,
gonna get into political
have you
stuff.
brought us an easy one or one that's going
It's
to, are you going
very
to need
easy.
your
It is
magic wands
very
for this
simple.
one or
It is
what?
a very simple one.
Very
It's-
simple,
It's a
huh?
residential addition. First, I basically, I'm going to hand up, I have 3 letters from neighbors, all in favor, the surrounding neighbors, 1 across the street and 2 on each side, and actually 1 neighbor's present. I'll mark them as, generally mark them all as 1, or there's 3 of them, or go A7, A8, A9?
I think we should, each letter should be
Yeah.
separate.
So I'll mark them as A7, A8, and A9. As I said, these are, I don't have copies of them, they're just, they're the neighbors adjacent and behind. And as you'll see, basically, we have, I'll go through the testimony too, but we have a lot here. It's on Rodney Road. The lot is undersized. It is non-conforming as to lot area. It's also non-conforming as to impervious coverage. Our thought is to remove the existing frame garage, which is about 3 or 4 feet from the property line, and move that up and connect it to the house. Thereby, we'll be reducing the impervious coverage, and actually bringing into compliance the impervious coverage requirement. And also, the new attached garage would be no closer to the property line than the existing detached garage. I will swear it all through. We have the architect and
Okay, if
the
you
applicant.
want to raise your right hand, you solemnly swear to affirm the testimony you're going to give the truth, the truth, and nothing but the truth.
Yes.
And if you state your names one at a time, please.
Ann Ledger. Ann Ledger.
Nick.
Christine Quisenberry.
Kurt Quisenberry.
There's 2, Nick.
And Eric, you're the owner of the property?
Yes, I am.
And you live there with whom?
My wife, Christine, and my daughter, Maeve, and son or daughter on the way.
And when did you purchase the property?
We purchased the property in November of 2003.
And I've marked as A2 a copy of your deed indicating that actually this is just the most recent deed, but you had
Correct.
actually purchased it before then.
Correct.
And then I'm showing you A3, and A3 is the current plot plan.
Yes, sir.
And Rodney Road is, this is behind Villanova Stadium, would that be accurate?
Yes, the first left you can make after the Villanova property ends.
Right. And the lot indicates that that is non-conforming as to lot area, correct?
Correct, yes.
The existing garage is 3 feet from the property line?
Correct.
That's the existing detached garage?
Existing detached one-car garage, 1 story, 3 feet from the back, 3 or 4 feet from the side.
Okay, and can you just briefly describe to the board what your intent is for the addition?
The intent of the addition is to, it's currently a 3-bedroom cape with 2 bedrooms on the first floor. One's used as a nursery, the other used as a guest room / den.
How big is the current home?
The current home is about 1,600 square feet. The upstairs is 1 large master bedroom, a small bathroom, and a small walk-in closet. There's a flat roof that there's no dwelling on, and the intention is to move the garage up to adjoin to the current structure and build an addition on the 2nd floor, as well as out to the 8 feet setback on the rear of the home. So we're looking to add enough space for a growing family.
And currently, you're non-conforming as to impervious coverage, and actually, what you're doing, you're removing some impervious, and so you'll be conforming as to impervious?
Yes, the intention is to move the garage up to attach. We found that would be the best way to get as much space onto the house while we're only covering currently paved driveway and then opening up the backyard to have more pervious surface. I think we're at like 42% now, and this brings us out under 40%.
And I'm going to show you as A4, and this is the plan prepared by Ann Ledger, who's here. And this shows basically that's in their packet, the addition and where it would be located.
Yes, the existing garage moves up about 14 feet to about 1/3 of the way onto the current structure and becomes attached, and will then add 8 feet as well to the rear of the home.
Okay, so this area here that's crosshatched back here, this does not need any zoning relief, this area here.
No, that all falls within the 30-foot setback.
Okay, and what you're asking for relief on is in this area where the garage now, instead of being 3 feet from the property line, the detached garage would now be attached and be 22 feet from the property line.
Correct. We'd be looking for an 8-foot variance there from the rear setback, and then the garage gets no closer to the side yard than it currently is. It just moves up and becomes attached to the home.
Okay. I'm going to show you some photographs that we've pre-marked. And first, if you can describe what 5A.
That is the view standing on Rodney Road, looking south to the front of our home at 6 Rodney. You can see the detached garage to the left and the front yard.
And the addition would be on the left side.
The addition would be to the left side with the attached garage now covering what is asphalt.
Then A5B.
You see the side of the house here where we currently have a small, it looks like a bay window. It's actually a little alcove off the eat-in kitchen. And you see what is our side yard now. The property line runs all the way to essentially on his driveway there at what would be 8 Rodney.
And 5C, basically, again.
Same picture, you get a little bit more of the right side yard.
And 5D.
This is standing in 8 Rodney's side drive, looking at what would be the easterly side of the house, which would now become attached garage.
Okay, and 8 Ronnie, that's Tom Main.
That is Tom Main, yes.
And we have a letter from him.
Yes, he's seen the plans, supports the plans, has no problems.
5E, again, just showing where the existing detached and where the addition would be located.
Correct.
And actually, that bay area is being removed.
That bay area would be removed, and it would be essentially attached garage.
And 5F?
That's looking from the backyard on what would be the westerly property side, looking east towards the detached garage.
And G?
This is looking at the rear of the home. You can see there's a current alcove that comes off the back structure that's been there, I believe, since the home was built. It's just a small closet. It sits maybe 3 feet off the back, and now the 8-foot addition will come to the 30-foot setback and run parallel all across the back of the house.
And H?
H, you see the full back of the house. The flagstone patio there would be removed, and as you see in the, I think, exhibit marked A4, the new flagstone patio would be moved to the center of the house, and a size of which could be kept so the impervious surface remains in compliance.
But, okay, he's still 30 feet. So he's going to move this up.
I have nothing further at this time with this witness.
Yeah, I have a question. You're going to, on this drawing here, I'm showing the drawing that's on the left-hand side, that correct? Okay. That little patio you talked about, is that the square that the 6 is inside, the arrow's pointing to? Where is that shed that we showed in, I don't know what happened to my voice, it's hidden north.
If you look at exhibit A4, the shed is the dotted line with the box 1 in the center.
Oh, that's why I said the one at box 1.
Box 1 essentially goes away and moves forward into the hashed area that's now attached as part of box 6.
Okay, that's what I meant. That with one of the arrows, the 6 is really box 1, is really the shed.
Yeah, the shed moves forward.
Okay, and that's
The
30
garage.
foot. In other words, you're at, from that point to the rear, you're in compliance with the rear yard, correct?
Everything over to the box is in compliance.
Right.
The box
To the garage.
To the garage, yes.
Right. Well, why can't you bring the garage up that extra couple feet and make everything straight across? And the only thing you need is a side yard variance.
I can have Ann testify better, but the intention is where you see the box 9 is going to be a side door entrance into, so there's both a front entrance and then an entrance on the side of the house where you'd enter into a mudroom. Essentially, that would be in front of the garage. So if you move it up, then any door on the, what would be the easterly side of the house would essentially enter towards the front, and frankly, my wife has a desire to have one of those mudrooms that has the nice white clapboards and cubbies.
Well, you see, but if you move it up, then she doesn't have to worry in bad weather. She can get out of the car and go right into the house. That's a better alternative than having to go outside and go into the house.
No, well,
Let's get some facts on the record before we.
Okay.
You know, I have some factual questions. Do you have any factual questions to ask them?
I don't know. Ask yours first, and I'll see if they include mine.
I mean, before we start debating principles of design. The distance in the rear of this plan, along the rear of the property line, from the new patio to the rear line is not shown. Do you know what that distance is?
I can scale it, Noah. Remember, there's no requirement on that, but I'll
Well, it's a
scale it.
structure. It is a structure.
No, the patio's not a structure.
Yeah, it is under our code.
No,
It's
it's
a
not.
structure.
No, it's a flat flagstone patio.
Well,
It's
through
never,
the definition of structure, maybe.
no, it's not a structure, no.
Okay. An
If it was
assembly of-
raised,
oh, wait,
if it was raised, it would be a structure.
An assembly of material forming a construction for occupancy or use, it's going to be used, including, among others, building stadia, blah, 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 okay. Open walls. Any man-made object having a discernible stationary location on, or in land or water. It's either in or on the land, and it's a man-made object having a discernible location. It's a structure under the code.
Then, in that definition, a driveway would also be a structure, and every driveway in the township would be in violation of the zoning code.
Well, that's not what we're considering right now, Nick.
Well,
This is a
but
structure.
no, that's, I mean,
So
you're going to absurdity.
I'm asking you to supply a fact. Can I have the distance?
I can supply that.
Okay. You're arguing as though you assume what I'm going to do with that fact, Nick, and you may not be correct. Only my wife can read my mind.
Oh, God, your wife before her.
Fortunately, she's not listening. She's at choir practice. Otherwise, I'd get that cited back.
And my
Right
microphone's
now,
off
when you got
also, in
home,
case
she'd
she
be
was
yelling at
listening.
you. I know you're right. She'd be yelling at you right now when if you got home. 10 feet. 10 feet.
Now, on the right side of the plan, there's this Bilko door being added, box number 12. Do we know what the distance is from where that structure is going to be to the sideline there?
5 feet.
5 feet, okay. Now, these two letters that were written, they're written, you said one was by Tom Main,
Yes.
and he's the property, as I look at this plan, to the left, right? Isn't that correct?
Yes, he would be,
Okay.
he's listed on, actually, if you look right here.
Right. Which plan is that? Is that the...
It's to the right, his name's on there, it's to the right, his name's on the plan.
Oh, I thought...
He's on the side where
If
the,
you open the plan up, it's to the right. His name's on
Okay.
the,
And and who's the neighbor on the other side? Did they write a letter also?
they're here and there.
Okay, well, can we have these letters written into the record? I don't know what those letters
Yeah,
say. I'd like to hear what they say.
And actually, if I can, because attached to those letters were, and I can introduce that, I just didn't hand it up, was the legal notice, the application, what's been marked as A4, or what's been marked as A3, as well as what's been marked as A4. I'll
no,
hand
do you want me
that
to
up
read these
too.
into the record?
Yeah, if there's no copies
Okay.
for everybody, we may as well have it.
And they're all the same. It's a same letter and signed by 3 different people. Okay. It says, "To whom it may concern, I reviewed the proposed site plan that has been submitted by Eric and Christine Quisenberry for their home at 6 Rodney Road, Bryn Mawr, Pennsylvania, 19010. I have no concerns or objections with this plan. I am also aware of the variances being requested in their appeal, parentheses, number 2885, seeking variances from section 280-30D1 and 280-30E to construct an addition or any other relief necessary from the code, close parentheses, being heard by the zoning board of Radnor Township and have no objections or concerns with these requests. Attached to this statement are copies of the zoning hearing board application, 2885, survey plan, proposed site plan, and impervious coverage. I reviewed those documents, signed them showing that I have reviewed the documents, understand and support them. Please do not hesitate to contact me with any questions. And the signatures are by John and Kathy Immor. I'm sorry if I mispronounced your name. And Kathy Burns, Thomas Main, and Brian Galloway. Brian Galloway lives at 9 Rodney. John and Kathy live at 4 Rodney, and Mr. Main lives at 8 Rodney.
Okay, thanks. The,
As I said, I'll know attached to that were the items I mentioned. I've marked as A10. I don't have a staple to put.
Nick, what's the square footage of the lot?
It is
6742 square feet.
742. Code requires 7,000.
so it looks like you're going to reduce the impervious coverage by 55 square feet.
Number them.
Is my subtraction right?
I'm sorry.
You're reducing impervious coverage by 55 square feet. I subtracted the 2,681 from the 2,736.
I think she has the numbers here.
I don't have that number of fingers, so I'm not
Yeah.
sure if my subtraction is good.
Existing impervious is the existing 2,736 and proposed is 2,680.
Right, so that's 55 feet difference,
Right.
square feet
Mhm.
difference. Right.
But that brings it into conformity too, because right now it's out of
And
conformity.
presently, it's in full conformity, it looks to me, with regard to all the yards. The accessory
Yes.
building is away from the principal building, and it's not closer than 3 feet to either the rear or the side. And on the side where you're putting the Bilko doors, you're in conformity. And the rear yard, you're conformity, and the front yard, you're conformity.
That's correct.
So you have no yard nonconformities now. And with this plan, you're going to be out of conformity with both side yards and the rear yard.
Well, we're out of conformity with the aggregate My understanding is Belco doors, again, there is no setback requirement on Belco doors, just like there's no setback requirement
Yeah.
on steps.
No, there is.
That's
That-
always been my understanding of how
An accessory
we treated it for
structure
the
that's
last
attached-
30 years that I've been practicing before this board.
Let's not match years, Nick.
And I'm sorry, I know.
Let's not match years. The accessory structure, it says in this section on R4, 280-32A, if the accessory structure is attached to a principal building, in which case it shall be a part of the principal building, and the principal building is subject to all the yard requirements. An accessory structure that's separate from the principal building at least has to be at least 10 feet away from the principal building and is subject to that 3-yard.
Yeah, I agree with that.
Right. So I believe you're asking for variance with regard to both sides and the rear, the sides in the aggregate and the sides in the minimum, and the rear. Isn't that what you're asking for?
Well, as I said, if the board was to consider Belco doors, Belco cellar doors, as something that requires a setback, I guess we would either have to ask for relief on that or remove them, so that we're not in violation of that side yard. So then we'd be asking for relief on the aggregate and asking relief for the one side yard, if we remove the Belco doors or the Belco doors are not applicable to side yard setback requirements.
Nick, I can weigh in on this. I know that this issue has come up several times throughout my tenure here and prior to that, and it's been interpreted by myself as well as previous zoning officers that Belco doors as a means of egress are not subject to the principal setback requirements. So that was something that was weighed in on that I walked into and have been carrying that interpretation forward. I know that has come up several times over the course of the last several years.
Right, we appreciate that, but of course, for the purpose of deciding this case, it's our interpretation that's going to rule this.
No, not correct,
Yes.
Noah, because
We have
the
to
zoning
interpret-
officer makes a determination, and then the applicant requests relief based on the determination made by the zoning officer.
Has there been a
board-
determination made in this case,
Does not
Kevin?
have the authority to overturn a zoning officer's decision
Has there
unless there's
been
an
a
appeal.
decision in this case?
There has not been a determination asked for or issued on that issue.
On this case?
On this case.
That's the end of
Well,
that
no,
issue.
but
Nor
we
has there
know
been a request for
they've
that
never
relief.
been determined to require a
Nick,
setback.
it's not on his case. Nick, let's move on,
Okay, thank you.
okay? No. Anything else, Noah? Any other facts you're looking
All
for?
for now, this witness.
Okay.
I have a question. What's the side yard on the eastern, because it's the eastern?
It complies to the side. It's currently 12 feet, it remains 12 feet, and that, at least that side yard complies, the aggregate does go
Right.
less.
But change from 3 to 4 feet here.
Okay, Peter?
Any way you slice it, they're going from a compliant side yard of 1812 to.
Right, so they need aggregate relief and
And
left-hand
need
side.
specific, because they're down to 5 on one of the yards,
Yeah.
which is less than 12. So there's
Yeah.
no way you need, they're in the same provision, but there's 2 components of that provision
Yeah.
that would fall out of compliance.
Right, which is what,
Yeah, we were discussing
moving the garage up?
moving the garage, yeah.
You done
Are
discussing?
you going to put on evidence of hardship? Is he going to furnish that evidence?
Well, go ahead. You got to come up and
You
speak.
got to use a mic, I'm sorry.
I know that the evidence of hardship is not supposed to be personal, but I think our request is, we've looked at a variety of ways on how to do this addition based upon the small size of the lot. And this is the most effective way to have the building be as compact as possible, gain as much yard as possible, and get into compliance on the impervious surface. My wife and I are both Villanova grads. My wife works for the university. I work in Bethlehem, but choose to commute because we love the neighborhood. We have one child and another one on the way, and the house just isn't big enough. but we'd like to stay in the neighborhood. We're not looking to have a McMansion or an acre lot. And by working with an architect, these plans most effectively give us what we think we need for the next 15, 20 years to live in Radnor Township, enjoy the township, use the school district and the facilities, be taxpayers, and be in a small, nice neighborhood. And we don't see, we've looked at a variety of ways to do it. We looked at for other homes in the neighborhood, and we feel this fits the best. We know we're asking for, 2 significant items of relief, but we think by doing it this way, it stays with the architecture of the neighborhood. It fits in with the neighborhood. The neighbors are comfortable with it, and hopefully it makes the most sense as opposed to doing something gimmicky like keeping the detached structure, trying to build on top of that, doing a breezeway. We thought of everything possible, and we felt this was the way to try to be as incompliant as possible while still giving us the ability to add a whole second floor. And frankly, that's why we'd like to have the attached garages, because we can then build over the second floor.
As I look at this, I'll ask a question, but it appears to me that if you move the garage forward enough to come into compliance with the rear yard setback, your side entrance is right around about 8 feet from the front door.
Unless it was in the garage, yes, sir.
Yeah, okay.
Yeah, we,
Are we going to hear from some testimony from Ms. Ledger about the design process
Sure.
and how they've
Yep.
come to this point?
and you're under oath.
I think the convincing factor for attaching the garage was so we could get enough second floor space, because the first floor footprint was not big enough to get the number of bedrooms that they wanted to have. I think as we slide the garage farther forward, it pulls the car and all the kids' bikes and all the stuff that's associated with the garage really into the front yard. And I think it was their intention to kind of keep that tucked back around the side of the house so that it would make the neighborhood look a little bit less, because they're going to have 2 young children and a lot of things in the driveway. So it gave them an outside entrance to get into the house without having to leave the garage door open all the time. So just from an aesthetic standpoint, I think it's desirable to have the garage set back farther and be able to keep the garage door closed rather than using that as a primary entrance on the side of the house.
Do you happen to know whether there are other buildings or other homes in the area, in this neighborhood, that have attached garages like this?
Yes, the garage next to us at 8 is attached. It's actually the slope, the topography of that neighborhood. We're at the bottom of a grade. His garage is attached. He actually comes into his driveway and pulls left and pulls underneath the home. There's a deck built above the garage. And then I believe that's the only attached garage on our side of Rodney. But if you go to Braxton, which is the street between us and Lancaster, there are 2 or 3 homes on the north, or which would be the south side, that have attached garage. And there is the house on the corner of what would be Blackfriar and Braxton heading northbound, the corner lot. That was an attached garage that they turned into living space. I believe every house on that side has attached garages.
And is it the same architecture of capes all throughout? And
Well, you just said it's below. But one of them is a garage below. It's like at a basement grade.
no, I understand.
2, I believe, they drive down into. A couple are attached that are flush with the front of the house.
Know if any of those attached garages are violative of the side yard requirement of the lots they're on?
I couldn't testify to
So
that.
it's really not the issue. He doesn't know if any of those are
No,
violating the side
that
yard.
was going to be my
Yeah,
next. That was
yeah.
going to be my next question.
I have a question for you,
I
Ann
do
Ledger.
have one.
I wanted to
did-
ask Ann.
I'm sorry,
question.
just in that one question, I did attach his A6 zoning relief that was granted to Rodney, actually.
Ann, how many bedrooms does this house have now?
3.
And how many will it have when this is done?
It has 3 now.
And it'll have
And
5?
2 bathrooms, and it'll have 5 bedrooms and 4 bathrooms.
5
Because
bedrooms?
one bedroom
4
will stay on the
bathrooms.
first floor, and the bathroom on the first floor will be used as the powder room. So upstairs will be...
That's a lot of house on a small lot.
Well,
5
the
bedrooms and 4
The
bedrooms.
bedrooms are small. One is going to be used as an office, study. But I was asked to try to get as much usable space and to have room available for growing family.
Mr. Cornelia, I noticed, I read the 2696 decision. I don't know who the knucklehead was who wrote this up, but in any event, this was a front yard setback relief, so it's different.
I was just looking for, and I was a knucklehead who represented this client too, and I had it in the file, so I attached it knowing it was adjacent or 2 doors down.
It doesn't say the extent of the relief or the violation or anything, really. It just
No,
says
this
it begs the plan, and that's it.
Yeah, it approves a plan. It was an uncontested order. There was no contest of the application. It was, for whatever reason, was granted as an order. There is a plan referenced in the order, but without the plan, all I can say is that this was a front yard relief, not a side yard or a rear yard.
Ms. Ledger, question. Did you explore doing it similar to what Thomas Mann did in his house? Because it looks like it's the same house, but he put the garage in the back, and therefore his relief looks like it was rear yard relief, and his side yards are in conforming. How?
We can only build out 8 feet behind the existing house before we reach the setback line. So
Yeah, well, I understand that, but I mean, it looks like he's got the same. He encroached on the rear yard as well.
Yes.
So what I'm saying is did you explore? I mean, you're looking for relief on rear yard and side yard and aggregate. Okay,
Yes.
It looks like from that plan that's there, it looks like the only relief he got, if it was any relief at all, I mean, I don't know how long it's been there, is the rear yard relief, because it looks like the side yards are in compliance. And if they're not in compliance, they're an extension of a nonconformity. So he's kind of in, he is in compliance. Did you explore that? Because then you would only ask for relief coming in the back.
I think our intention was to move the garage forward to decrease the impervious coverage and to give them more open space in the backyard. By attaching the garage to the back of the house, it would have been sitting in the backyard and they wouldn't have had much yard space. So our intent was to
Yeah, the same thing next door has.
Yes, but their intention was to have more of an open backyard. So by sliding the garage forward, we decreased impervious and also gave them more open space in the back.
And if you slid it more forward, you decrease impervious even more, and
Yes.
you'd have bigger backyard. And
We
you'd walk
would,
from the
but then
garage
all-
into the house, which is really, I'm telling you, that's a real
but then
big deal. It's a
then the
big deal,
garage
especially at night when it's raining. You come home, shut the door, and you're in the house. You
Well, the
don't have to
garage
worry
is
about it.
attached to the house. You can go into the garage and get into the house. By moving it forward, then you really have to keep the garage doors open all the time because that's your back door.
Or you
and
just put a
from
door
the-
in a garage.
Well,
I mean, there's,
there are ways we can organize it.
that's correct. There is ways you can kind of get around it. Any other questions? Nick? Court? I don't know, it's up to them. They got to make
Yeah, I
your
know.
call. Make your call.
Can I take, I guess I'm wondering kind of where the board stands on this to some extent.
Is your case closed?
I know where your stand.
Is your
now. You don't
case
have to tell me
closed?
that.
Nick, I mean, is your
No,
case
it's
closed?
not closed, no.
Well, why don't you put on the rest of your evidence,
But-
and then
but-
we'll discuss it in front of you.
But what I'm asking for the board is, certainly, I think I know Mr. Falcone's position as to the rear yard setback issue. And I don't know if other members of the board have a position on the rear yard setback or not.
This isn't a negotiation, it's a hearing.
I understand.
Let's,
I'm in favor of the plan as it's presented.
No,
we're not there yet. His case isn't closed yet.
I don't really have trouble with the side yard, but I am a little troubled with the rear yard. personally.
You made some comments that you are moving the garage forward, right?
Yes, sir.
So that it will be 20, instead of 22, it will be 30 feet?
It's currently only, I believe, 4 feet from the backyard.
Okay. Yeah, that's out, anyway.
So we're going to move it forward, and instead it would be 22 feet from the rear yard as opposed to 30 feet. The 14 feet width of the garage would be 8 feet into the rear yard setback.
How far can you go?
Well, you
forward?
know, I've spoken to the clients. We will remove the request for rear yard setback variance, and we will just be requesting the side and the aggregate. So the attached garage would have to be 30 feet from the rear property line, which is in conformity with the zoning code. So we would move that request for rear yard variance. So we're left with aggregate and side yard.
So what you would do then is you wouldn't move it further forward, you would just take something off.
Oh, no,
the
we move it
back.
further forward. Yeah,
move
we
it
would
further
move the garage further, just so the
Need
board's
the depth
aware.
of the garage.
We would move the
They can't-
garage
they can't
further
shrink the garage.
forward. It would be the same length and the same width. It would just be moved further forward.
So they'll be in compliance in the rear yard.
I'm done. I close my case. And request the exhibits to make part of the record, please.
Very good. Well, then we'll have a vote. Jim,
Can I have a discussion?
you want to have a discussion? Okay, you want
Yeah,
to,
I think
okay.
we should. I think people are entitled to know why we're doing what we're doing, and who wants to start?
Public, yeah, there.
Is there anyone in the audience that,
He would,
you wrote one of the things, correct?
Hi, I'm John Immervarm at 4 Rodney Road.
I promise to tell the truth, the whole truth, and nothing but the truth. John Immervar, John, Immervar, M as in Mary, ERW, AHR, and my wife Kathy Burns is also here, and her name is BYRNES, Kathy with a K. So I'd just like to say, as one of the neighbors, I really support this. I would say the comments that we are comfortable with it are understated. I think we are enthusiastic about it. I think it will improve the quality of the neighborhood. You know, these houses are kind of old, and a number of them have been expanded in one way or the other to bring them more in line with what people are looking for these days. And this will be, I think, a terrific addition. Plus, it will keep these lovely people in their neighborhood, which we look forward to. So, what else can I tell you?
You said very much. That's very
Okay,
good.
thank you
very
so much.
Does your wife wish to say something?
No, but I agree.
Okay. Any discussion?
I have a question. That number 9, is that going to move forward to the same format? Section 9.
I'd have to speak with Ann, but I believe 9 would then be within the garage, that the door would probably stay where it is, and there wouldn't be a structure, because as Mr.
Right.
Craig pointed out, it would literally be a door around the side of the house from the front. So that number 9 would actually become an entryway through the garage into the
There
house.
is no step there
There would be a step up in the garage, but there wouldn't be a step
to
into the garage. No, sir.
Thank you.
Discussion. I don't find a hardship. I think not having a 5-bedroom, 4-bath house on a lot that's already too small to even be in that zoning under current zoning in that district is not a hardship in my view of how the law defines a hardship. And allowing a principal residence to be within 5 feet of a sideline is not justified in order to achieve that end. I believe, as a matter of this board, that these attached accessory structures are part of the principal residence under 280-32 sub A. And so that they're basically asking for variances now, not from the rear yard. I guess we'd have to see a new plan showing that, but from both sides, it would be violating from both side yards and the aggregate yard. And I guess in the rear yard, on the patio as well, because I didn't write the code, but that's what it says. So I don't think there's a hardship, and I think the relief is excessive for the size of the lot.
Any other comments, questions? Jim?
Well, I think Noah makes some good points, but it would be my view to approve a variance for the side yard and the aggregates as requested based on the size of the lot.
Peter?
I agree.
Noah?
Voting, or are we still in
No,
discussion?
we're on voting.
No, I vote against it.
Cora?
I go with the new changed configuration.
I would agree, the stipulation being that the garage does move up, so that there is no rear yard encroachment at all. You're going to be within 30 feet. And the aggregate stays, is the 5 feet on the, is it the west side? Is that the west side? Okay. And that, that there's, you keep on the east side at 12 feet.
What about a variance for the rear patio? Are you granting that? To be within 10 feet of the rear line?
I'm sorry?
I don't think they've sought relief for that. So to the extent that wouldn't they come before us on a violation?
Well, I mean, we have to decide, is that a
Yeah, but that's not in
a
front of us.
structure?
Yeah, but
Is
that's-
that a structure?
I don't think, well,
Kevin, do you have?
I mean, they've given us a
Kevin,
plan
do you
that
have-
shows it, and we have to decide, is that a structure?
First,
I mean,
it's
I
not an
believe the code
attached.
says it is.
It's not attached, so if it were considered a structure, it would not be an attached structure.
It is
Second,
attached by steps, and it's attached.
Patios, unlike decks, are treated differently, and patios per code, I believe, can go up to the property line, as do driveways. We treat those similarly, and walkways.
Well, where's the
So-
code say that, Kevin? I'd like to
Well,
know. Maybe I'm wrong.
I don't
Where's-
have the code in front of me.
Okay.
I can go off of what has been historically interpreted by the zoning officers in Radnor Township, that does not fall within a violation of the code.
And if that, if we took it to that extreme, I think that Mr. Cornelius' comment that driveways would trigger violations.
Yeah, but we're not considering a driveway now. I'm just looking. There is no definition of patio in this code that I can find. There is a definition of structure, and
The
I
driveway in
read.
this plan would violate the code.
But we don't pick and choose
We're
what
not
structures we
approving
don't
this.
want to regulate from that standpoint. So we would agree that patios are no different than driveways, if you're going to look at the true definition of structure as a man-made object having an ascertainable fixed location on there.
So then we're holding as a board that a patio is not a structure and a bill code door is not a structure. Is that what we
It's not-
intend to do?
It's not before us, Noah, so I.
Well, they've
I mean,
given us
you
a
know,
plan that shows
Yeah,
they're going to
but-
come within 5 feet with a bill code
But
door.
we're only voting on what's before this board in this appeal. I mean, if there's a problem, then it's up to the zoning officer to recognize that problem and bring it back in front of this board and issue a citation or a work
But you're
order
granting them
against that.
approval. As a board, you're saying that allowing this bill code door to be within 5 feet of that sideline is either not a violation or we're giving them a variance to do that.
Yeah, but I don't think we're doing either one. I think we're voting on the appeal and what they asked that's in front of us. I mean, if we see something else, it's really up to Mr. Kaczynski.
Well, they didn't ask for a specific relief. They didn't say we want a relief to come this close with this. They're not that specific in their application. They asked very generally for the relief. So what relief are we granting, Charlie? Are we giving them relief that allows them to build that within 5 feet in the form of a variance, or are we interpreting that that's not a structure and therefore not part of the principal structure? We have to be doing one or the other.
Well, I think, from my personal opinion, I have never considered Bilko doors or patios as part of the structure.
It's not just a door. There's concrete steps. There's a concrete frame of it. The steel doors sit on top of it.
This is almost very similar to Lowell Court and its steps that went down into the basement. You know, since it's underground and since it's built that way, it's never been determined that it encroaches on side yards.
And historically, that's the way the zoning ordinance has been interpreted by the zoning officer, that patios and Bilko doors do not need to meet the principal setback requirements of the structure.
I mean, that really requires an amendment to this ordinance. Well, that's not what the ordinance says. I'm not going to the issue of whether that's desirable or not desirable. I'm just saying the ordinance says what it says, and we're limited into how far we can change it by interpretation.
Well, I think everybody can agree that you may read an ordinance different from me, different from Nick, and ultimately the zoning officer, whether it's me or those before me, have made that interpretation, have been consistent with that interpretation. I'm carrying that interpretation forward.
I'm a little uncomfortable.
I don't understand. Where are the Bilko doors, and where are they? I see where they are in the photograph, but where are they going?
They're on the side, the opposite side.
Box 12. That's a 5 foot.
I don't think we do.
No, I don't think we do either. I think that the only thing we only have to, and John can talk about this, address this legally. I think the only thing that we're required to do is on what he appealed, or what he's asking for a relief on, and that's section 280-30D and 1, because he's removed the 280-30E, which is the rear yard setback. I think that at some point, if NOAA feels and this board feels in the future that we're going to look at patios as structures or Bilko doors as structures that are being included in side yards, then I think we need to bring that up and have the ordinance changed. But
we're required to give the minimum relief necessary to alleviate the hardship.
No, I did not ask for relief.
Wait, well, this is the discussion of the board, Nick.
But
Wait
you're asking, I didn't ask for relief. I didn't ask for relief on the Bilko doors or the patio. I'm not asking for relief on that.
You know, I'm voting that we accept as what's going on in the past, that the patio in the rear and the Bilko doors have never been determined to be that.
I concur.
No? Cor?
About the patio, is that patio needed for this plan?
I think
that, you know, the confusion here, Noah has a good point because it is connected with the main building. So I know that you have calculated that into the impervious surface. That I can agree with that.
folks, may I just, we're now, because of a detail on a plan and a philosophical difference of opinion as to what the code could be made to say, are about to, without publication, are about to, it sounds to me we're about to announce a major policy shift. I do believe that the code could be read the way Noah is reading it, but if that is true, then every driveway in this township almost is out of compliance, and I don't think we should be, and it's not necessary. They're not asking for relief for the patio, they're not asking relief for the Bilko doors, and if the township wants to, and we're only going to approve the
well, then let's be specific in what we're giving them. We're giving them relief to violate the 1 yard so that they can build this structure within 5 feet of the left line.
The opinion will say that. The opinion will say
and the right, and no relief on the right side, and relief to have the total be the distance on the right side plus the 5 feet on the left side. And no relief as to the rear yard. If you're that specific, then I drop my objection to that issue. I'm still against approval, but I drop my objection to that issue.
That's how I always draft. I always tie it to specific ordinance provisions and say no relief is granted with respect to any other provision of the zoning code. Personally, I think to interpret the code to pick up the patio and the driveways would actually create real problems under the, concept that ordinances are supposed to be construed in a reasonable manner. And I think you'd be under attack if you were to put almost all the driveways in Radnor Township out of compliance, even if there is a basis for that. But we don't have to get there because...
Well, that just goes to the issue whether our structure of our definition of structure is a good one.
Yeah,
but that's not our purview.
Again, I think the issue is I will, if the board approves this, I will write it so that there is no relief with respect to the rear yard and no further relief with respect to the, let's see, what's north on this, by the way?
Not indicated on the small plan.
It would be probably on the actual existing plan. I'm sure there's an arrow.
Yeah, I see it.
There it is.
I see it. It would be on the northern side of the property, actually.
North is here, so the relief would actually be on the
south.
Eastern.
No, north where the arrow is.
Pointing this way?
It's the southeastern side yard is no relief, and the northwestern side yard gets relief.
No.
No, northeastern, wouldn't it?
Opposite. No, look at where the arrow is.
Yeah, here's the arrow here.
Yeah.
So
that's in the northwestern quadrant. That's in the northeastern quadrant.
No, the north.
I'm southeastern quadrant. Southeastern. That's southeastern. That's.
Well, it's the eastern quadrant. I think we're.
Okay. I think it's always been my opinion that the zoning officer determines what's allowed under the zoning code and what's not allowed under the zoning code. And that's why we're here, because he determines, as it's always been, that driveways and patios, okay, are not subject to side yard and rear yard or whatever front yard setbacks. I think that if
that's not the same as a Bilco door. Bilco door is a structure. It goes down into the land. It's attached. It's concrete and steel. It's a structure the same as your houses.
Potentially, you're right. The problem is now with the new ordinance that all basements need exits. Okay, I think that we've come to a different place relative to that.
This basement has an exit now. It's in the rear.
Yeah, but it's not going to be in the rear when he does the addition.
Well, that's what I'm saying. But I mean, they're creating the situation. They can't create a situation and then ask for relief on it. It's self-created.
No, that's not true. They could get approval. First of all, I respectfully disagree with Mr. Cornelia that a zoning board is stopped by the zoning officer. We can raise issues sua sponte that we have a problem with, but we don't need to go there on this case because the relief that, if this is approved, that you're crafting, will not pick up the patio or the Bilco doors. Just won't, and they're at risk with the township on that.
I think that's kind of what I said. Is the only relief we gave them is the relief that they required, that they asked for.
Not what they asked for, because they've asked for generally any relief necessary to build this thing. They're very general in their prayer for relief.
But I was pretty specific on what I granted.
I told you, if you want to frame it that way, that it's relief to go 5 feet of that left line, and it's no other relief from the yard requirements. That's fine with me, although I still object on the grounds that I don't think it's a hardship that supports it.
I think we crafted our relief saying to the fact that the relief that he gets is relief under, I think it's 280-31, I believe it is, or E1, or D1, okay? And he must comply with what the zoning officer, any other requirements the zoning officer so decides. So if the zoning officer believes that that the Bilco doors are encroaching, then they need to come back in front of us or remove the Bilco doors.
Mr. Chairman, could we just go on the record for one quick second?
You mean off the record?
On the record. Okay. We're off the record now. Mr. Cornelia, if this is approved, would you be willing to state, you and your clients, on the record that we are not giving any rear yard relief without saying that the patio is or is not part of the structure? We're just not talking about that. Right. And the same with the Bilco doors. And if you would accept that. And
yeah, we understand, and we didn't make we withdrew our application for rear yard relief. So we're not asking for relief.
And we're not asking you to
setback.
to say that admit it's a structure,
Right.
we're just not going to go there on this.
Right. And on the west side of the property, we're not asking for any relief on the west side setback.
Yeah, so,
And I think that's what we said in giving you your variances on the one thing, is what you asked for, relief on one side and the aggregate.
And the aggregate.
So if you're not if you're encroaching on the other side, then you either need to come back in front of the board or do away with the doors.
if it's determined that that's an
That's right.
encroachment. We're not talking, we're not addressing it in any fashion.
Is to make those determinations, and I think he does an exceptional job at it.
Okay.
You can pay me later.
And you are also just sliding the garage forward. You're not
Yes.
going to make
Yeah.
it bigger. It's the
Right.
same
No.
dimensions.
Just sliding it forward.
move
Same dimensions.
And I think you're going to
Sliding
enjoy with your garage door, getting out of your car in the garage. I think that's, I've been there both ways, and I'm telling you, the other way really is better. Okay, we done voting? Okay,
Thank you.
done, thank you. Let me find my papers, and I'll be right with you. You want to take a break? How about we take a 5-minute break while I organize myself and we get going on the next one. How's that? Is that okay? And again, thank you for letting the other one go first. I truly appreciate it.
If you hold it like right.
2884, I think that's the right one. Applicant 615 Newtown Road Associates LP with property located at 615 Newtown Road and zoned R1 residential. This is continued from the October 20th, the October zoning board meeting. Also included in this is Appeal 2886, which is same applicant 615 Newtown Road Associates LP located at 615 Newtown Road, zoned R1 residential, request a variance from section 280-112D to allow regrading of certain man-made steep slopes. Alternatively, the applicant requests an interpretation of section 280-112 does not apply to man-made steep slope. Excuse me, George.
Good evening, members of the board. George Brosman, representing the applicant in both of these applications. Just for clarity of the record, what I would propose is that we will do these simultaneously, but they are two separate applications. 2884 had been continued from last month and deals with a front yard setback issue, and 2886 deals with man-made steep slopes. So I would propose that we just finish up the one, close that record, and go right into the other, if that's acceptable to the board, because I have
Okay,
marked out
good.
separate exhibits.
Good deal.
So with regard to 2884, we were here last month. This is the proposed subdivision of the property that's owned by the Atterbury Estate at 615 Newtown Road. We put on quite a bit of testimony. We are requesting a front yard setback variance for the proposed lots in the subdivision. When we were here, it was October 18th, and we were hoping to appear, and in fact did appear before the Radnor Township Board of Commissioners on the following Monday, which was October 22nd. And the board, I think, on the 18th was rightfully concerned that the exhibits we had presented last time showed various different options because we did not know what the outcome of the October 22nd Board of Commissioners meeting was going to be, mainly whether the Board of Commissioners would grant the applicant a waiver of the subdivision and land development ordinance provisions regarding the right-of-way width for the proposed road. As you know, the right-of-way width for the proposed road is critical because that's where you measure the front yard setback from. So I think the board was uncomfortable proceeding unless it knew what the result of that waiver was, because you wouldn't know where, if you were inclined to grant relief, you wouldn't know where it would be on falling on the lots. So I was going to call Mr. Orsatti back to the stand and have him briefly run through what happened at the Board of Commissioners meeting. You also asked us to revise our site plan to show the front yard setback that we're asking, and I'll have him introduce that. By the way, as he will testify, the Board of Commissioners did grant preliminary subdivision approval for the subdivision, and they did grant the waiver requested for the 28 feet, and I'll be putting in through Mr. Orsatti a copy of the approval resolution. So is Mr. Orsatti still under oath?
Yes.
I believe so, yes.
Absolutely.
Joe, for the record, when we were last here before the board on October 18th, the board suggested that we continue the hearing to see whether the Township Board of Commissioners would grant the preliminary subdivision approval and certain waivers with regard to the right-of-way width for the proposed cul-de-sac that would serve the proposed development. Is that correct?
That's correct.
And on October 22nd, 2012, did the Radnor Township Board of Commissioners grant preliminary subdivision approval and the requested waivers?
Yes, they did.
And I have, for the record, which I have marked, are you familiar with the approval resolution that we received?
Yes, I am.
And I'll hand that out for the board. For the record, it's Exhibit A12, which is where we left off. It has a cover letter from John Rice, the Township Solicitor, addressed to me, dated October 23, 2012. And Pat is going to hand these out.
Thank you.
And Joe, under this Exhibit A12 on page 2 of the resolution, which is the third page into the exhibit, item number 7, is that where the waivers are in fact granted for the right-of-way width?
Yes.
And in fact, it was granted to be 28 feet. Is that
That's correct.
Instead of the standard right-of-way width, which is 60 feet. And have you modified the front yard setback exhibit that we had presented last time to show the reduced right-of-way width that has been approved by the Board of Commissioners?
Yes, I have.
And I have up here on the board, and if, would the board like smaller copies of this as well?
Please.
Do you have them?
We do.
I mean, did you put one in the new plan I can put in the folder, in the file? Do we have them? Do we have it? Do we have that? Is that the new plan that we made?
Yeah, this is not in your file.
Okay.
We're handing this today.
What are you going to call this, 813?
Yes, this is A13 for the record. It's entitled Zoning Setback Exhibit, and it is dated October 8, 2012, plotted, or last revised is revision 1, 11/15, 2012.
Put that one on the record? Okay, there you go, thank you.
And this replaces old A1F, right?
I think it replaces, we used A7 last time as the zoning setback exhibit.
But it's the same as A1F, I think.
Oh, that probably is. A1F, I guess, was what was attached to our application.
Yeah,
that's right.
This is the old plan. It's the same as A1F.
That's right. So you'll recall on that old exhibit, Mr. Ryan, that it had a lot more colors than this one because we were speculating about what the right-of-way width would be. So, Joe, could you explain this new exhibit A13?
Yes, if you're familiar with this site, again, Newtown Road is at the top of the sheet, Chandler Lane down to the south, and the Friends Meeting House to the east, and there's another subdivision to the west side. It's basically the same cul-de-sac concept with the 7 new lots and the existing residents that we're retaining. The difference in this plan is that the new 28-foot road right-of-way waiver, which was given us, then establishes the new 35-foot front yard setback that we are seeking. That is shown in the yellow line, and as you can see, the 7 new lots are moved forward towards that yellow line, and they touch that line. The blue line is the old 60-foot front yard setback that we're asking the variance from.
So the difference in A13 and A7 is, sorry, the difference between A13 and A7, if you've moved all the houses forward, if the houses were kept where they were in A7, you'd be in compliance with, you wouldn't need the relief, right?
That's right.
That's right.
But so you just moved them forward. Okay.
Yeah, when we were here last, I thought one of the things you asked us to do was to show
Oh, no, we did.
what they would look like.
I'm not offering.
Now, Joe, this topic was touched on a little bit last time. Did the Board of Commissioners, and maybe you can highlight Exhibit A12 on page 1 of the actual resolution, did the Board of Commissioners address the topic of a conservation or deed restriction upon certain natural areas of the lot in an amount equal to any front yard setback variance relief that might be granted by the zoning board?
Yes, I did at item number 3 of the resolution.
And would you read that?
The applicant must execute a conservation easement and/or restriction upon an area to the rear of lots 1, 2, 3, and 4 equal to the front yard setback area reduced as a result of any variance relief granted to the applicant by the Radnor Township Zoning Hearing Board in a form and manner approved by the Township Solicitor.
Now, on Exhibit A13, have you showed an area along Newtown Road? We were talking last time about the importance of the view shed along Newtown Road. Have you showed an area in red that is intended to satisfy the condition number 3 of the Commissioner's resolution?
Yes, we have, and that is shown on this plan in a dash red line that extends the full frontage of Newtown Road. It's approximately 35 feet in depth from north to south.
And did the Commissioners ask the applicant and, in fact, imposed also, in addition to that, so over and above the amount of relief granted by the front yard setback, did they place a condition in number 4 regarding the riparian buffer area to the rear of lots, say 5, 6, 7, and 8 on this plan?
Yes, they did.
And what does that say?
That, again, is item 4, applicant must execute a conservation easement or restriction along the riparian buffer area shown on the plan, limited to incorporating the requirements of section 228089.1 of the Radnor Township zoning ordinance in a form and manner approved by the township solicitor.
And you showed that general area also on A13?
Yes, we did. Again, it's in a red dashed line, and it generally follows the riparian buffer defined under the engineering plan.
And so if I understand it, that riparian buffer area, that would be, if you counted up the area, that would be over and above, beyond, if the board granted the full front yard setback relief we were requesting, that would be an additional area subjected to restriction beyond the front yard setback area.
That's correct. Actually, the front conservation easement along Newtown Road is equal almost exactly to the relief we're granting. By adding the riparian buffer, it almost triples the amount of acreage, and it goes to 1.76 acres. So it's almost 3 times or more than 3 times what the relief we're asking.
Mr. Roseman Arsadi, it seems to me, looking at the conditions, that the conservation easement along Newtown Road hinges on whatever variance relief, if any, is granted by the board. But the conservation easement on the other side of the property along lots 5 to 8 is unconditional. As I read the condition, you're simply supposed to kick that in regardless of what the board does.
Yes, we agreed to do that with the board, and your reading is correct. The 1 and number 3 hinged on any relief. That was actually got its start from the Planning Commission. They thought of that as an idea, and it was adopted by the Board of Commissioners that there would be that equal amount given. And then
Can I ask one, just another question? We had some discussion about last time whether we should be giving a general setback line variance or whether we should be giving setback relief for certain footprints, and you have footprints shown on new Exhibit A13. Did the Board of Commissioners make any statement as to whether they supported a general setback variance or a specific setback variance for these buildings, with you having to come back from further relief? Was anything said about that?
I don't know that it was said, but what I believe is, and they understand that we were at preliminary subdivision plan. These houses are just conceptual in nature at this time in the process. They probably will be until somebody comes in for a building permit. So I think it was very clear that they were just supporting the concept of, through the waiver of the right-of-way width and through just the general front yard setback variance, doing everything they could to get the houses as they would be built moved closer to the road and away from the natural features. So my view of it is it's a general thing. We won't know the specifics until the lots are sold and until the individual buyers come up with a plan. They'll have to apply to Mr. Kachansky and the township engineer for what they want to do, but we're sort of laying out a program for them to say, if we get this relief, here's what you have to work with.
Did the township write these conditions?
Yeah, these were written by Mr. Rice.
Because I have to say, if I reading 3, if it's equal to the front yard setback area, that would suggest to me a general line rather than specific footprints, because the area in the back is a lot bigger than the aggregate areas of the houses that are on between the blue and the yellow line.
Yeah, what was intended, Mr. Rice wrote this and I reviewed it. What is intended is to, so if you take the total area between the blue and the yellow line and add all of that up, that's the amount. So I think you're right. That's further indication. It's a general relief because technically each house may only encroach partially in the setback. So we're not looking to limit it. We're just saying if we get this general relief, this amount, this whole amount, the difference between the blue and the yellow will be what goes into the conservation easement or the deed restricted area.
Now, is the area between the blue and the yellow just the area along Newtown Road?
Yes.
Okay, because the stuff in the opposite side of the property near Chandler Lane, that's just being put in regardless of what the board does.
Yes, that was an accommodation with the Board of Commissioners.
I'm just trying to understand the facts. I'm not commenting.
Understood.
I just want to make sure the board understands what is before it.
You have it precisely right.
George, last time we talked about the need to move things up so that we wouldn't have to cut out way more trees in the back. The idea was let us hug the narrower road if they grant that, which they've now granted, so we can move everything up and leave the trees. But these areas don't seem to preserve what you show as trees on here. I mean, are these trees going to remain as shown here?
No, this exhibit is conceptual. As I've said, each lot is going to have to come in and decide what house are they going to build. And what we're asking is, can they be told they can work with the yellow line, or do they have to work with the blue line on Exhibit A13? Our view is if they can work with the yellow line, they will end up being able to save more of the areas, but we don't know.
But they may not.
They may not.
Yeah, because, I mean, your relief was expressly stated last time as being intended to save trees and other natural features. And as you recall, the discussion that we had at the time on that issue was, I think, that while we're giving you the area within which to save the trees, there's nothing that binds you to do it or binds a subsequent lot owner to do it. So if the hardship is the trees that you don't want to damage, then we have to grant relief to address that hardship, so we have to protect those trees somehow. And doing this doesn't protect them. It gives you the area within which to protect them, but someone may choose to build further back, or they may choose to build up there and have a bigger backyard and take down the trees anyway.
Yeah, I
so, I
think
mean, how are we addressing the hardship just by giving you this relief?
I view it as separate, that the hardship is the trees, it's the slopes. We talked a lot about the view shed along Newtown Road. We talked about the natural areas. So what we're saying is, if you don't give the yellow line and you force the blue, there will undoubtedly be more disturbance on each lot. We don't know where they will be. We struggled with this issue with the Planning Commission and with the Board of Commissioners, and that's the whole reason why they crafted condition number 3. We testified last time that the most important thing to save was the view shed along Newtown Road. So we offered, the Planning Commission and the Commissioners suggested that it would be, an equal, and as I pointed out, it's actually more because the houses will not obviously occupy all of these areas. So we're giving this equal area. This will be protected. And we believe that if you grant the yellow line, more will be protected. I can't tell you exactly what will be protected, but if you don't grant it and the blue line comes into play, I can assure you that there'll be a lot more devastation to the natural features.
But someone may decide they want a bigger front yard and pull it back there anyway. And if they're within the permitted building envelope, they'd be perfectly within their rights to do that.
They could do that.
And then the trees might go.
Anybody at any time could say, I'm not going to take advantage of a variance that I get.
Hey, now, a question. Can we require them that all houses have to be on the building line? Is that something we can do as a board, as part of the contingency?
Well, I don't know about that, but I think you can certainly say that, that there's some kind of relationship. Let's think about that.
Well, I mean, if we say that all the houses have to be built on the building line, then his argument is null and void, because what you're saying is if they move the house back, therefore they're going to take more trees down.
Yeah, but even if someone builds it up there, they could decide they want to put a big swimming pool in their backyard.
Or they could
and still take out trees.
They want to just.
Yeah, but they can decide to do that and move it back. At least we're saying that all the houses are going to be the same all across the front.
No, or even this plan doesn't show them all towing that line.
Charlie, they could decide
one
to
more behind it.
perpendicular to the building line.
I
think we're trying to control a little bit.
Yeah, I mean, we don't want to control them that much. I think that the problem is, though, we have to give them relief that addresses the hardship. And it has to be the minimum relief to address the hardship. Now, allowing this reduced front yard gives them the ability to deal with the hardship, but it doesn't assure that the hardship will be addressed. It just gives them the legal ability to do it, but they may not do it, or the people to whom they sell the lots may not do it, and that doesn't take care of the hardship.
Yeah, but if we say that you have to build on the line, At least we know the beginning of the house is going to be on the line. So we know it's not going to be any further back.
It strikes me that that's a little imprecise, and if the desire is to save trees, let's say they do build the house on lot 8, exactly where they say it's going to be built, and then the owner decides he wants tennis courts or doesn't like trees, the trees would come down. It's an indirect way of getting at the problem if that's the hardship that's being addressed.
I understand, but if let's just say he says, well, I want a bigger front yard, so I'm going to come 10 feet off of that, and decides to build the tennis courts or the swimming pools. So now you're going to have 10 feet more damage in the back. At least we're saying everybody's starting in the same position. If they do something in the back, we don't really have. And again, if they do something in the back, they're supposed to go in front of shade tree. And if they knock anything, a heritage tree, which is what, 12 inches, 6 inches in diameter? What is that number?
36.
I'm sorry, 36? Okay, they got to replace it with 4 trees. So anybody that's knocking trees down after the fact, whether they built the house or after the fact, if they get caught, there's a fine, plus they got to replace the trees.
As a practical matter, they could build with either one of these lines and still not hit the trees. The houses aren't going to go to the trees on any of these lots, as I see it, no matter where you do it. So the issue isn't really the house. The issue is what goes on in the backyard, wherever you put the house. That's really the issue.
Yeah, but technically they're not supposed to touch any trees in this township without going in front of
Yeah, but I mean, that's a different issue. But I'm saying they're here because of the hardship.
Yes.
We have to address the hardship. How do we address the hardship and make sure that the relief we give them alleviates the hardship? We have to somehow bind them and future owners not to cause this hardship by taking out these trees. The jurisdiction of the Shade Tree Commission is something over and above us, has nothing to do with us directly. But the fact that we can only grant relief to alleviate a hardship in the minimum amount necessary. So how do we relieve the hardship? I know we're giving you the ability to help the situation by moving them up.
Right. Any variance applicant can say, I'm not going to use the relief, I'll just comply. I personally believe, with all due respect, that you're tying two things together. You're talking about conditions and things like that. We either have a hardship or we don't. It's up to us to decide whether we will use the relief.
I wasn't really going there, George. In other words, as some of the other members of the board are saying, well, how do we do it? But I'm just saying, you understand how we have to have this nexus between the hardship you're seeking relief from and the relief we give you to alleviate that hardship.
Is, I think you're making the nexus, you're connecting it with the wrong thing. We do have a hardship, and the relief is related to that. You're trying to tie it then with other kinds of conditions. I don't think our hardship depends on any conditions you would grant. Our hardship is the natural features, and by moving up the line, we can avoid those. We've placed this easement on an equal amount of area. It'll be more of an area.
Maybe I'm making an assumption. Let me ask Mr. Orsatti. Joe, is there any physical feature existing now that would keep the houses from being built with respect to the blue line at the required setback under the zoning?
Is there anything preventing?
The actual houses. In other words, can they be physically sited behind the blue line? Can they comply?
Certainly.
So there's no reason why the houses can't be built in compliance with the existing. And the only reason they can't be, you're saying, is that'll kind of force the whole plan back. And if it forces it back, it's more likely that it's going to affect adversely the trees that are.
I mean, we have a by-right plan, and we could go in, and we don't even have to come here and ask for the variance.
Right. I understand.
What we're trying to do is, I'll just tell you right off the hand here, in this swath that we've established as a conservation easement, there's about 50 trees in there that basically we're guaranteeing those trees will never be touched. Isn't that one of the things you wanted to see? And in addition, there's another 100 trees down in this easement. There's a tendency for all the builders and all the people we've talked to, the buyers, to want to save trees as much as possible. 10 years from now, if somebody comes in and wants to build a Olympic-sized...
Excuse me, can I ask a question?
Can I finish my comment?
Yeah, okay, go ahead, do that.
10 years from now, if an applicant comes in and wants to build a swimming pool, they have to go through your checks and balances here in this township. They've got to submit a plot plan, a permit. They've got to go they got to check the impervious cover. They have to check the disturbed areas against the land approval plan. Have you ever been to a shade tree commission? I've been to 12 of them in the last 2 years. It's an incredible experience. Those guys are tough. And I guarantee
Yeah, but all we're really doing,
this is
Joe,
not going to prevent.
at the end of the day, all we're doing is giving you a bigger building envelope. And what you or the next guy does with it, we really don't have a whole lot of control over
You do
beyond
have
this
control.
beyond this easement
You
area.
do have control. You have a staff here that will.
No, but I'm saying within the
scrutinize.
scope of this board to grant relief, if that's the basis. In other words, we want to enable you to do this if it really gets done. The point is, how do we know it's really going to get done, or we're just giving people a bigger building envelope?
And the issue we have is that I've explained is, we don't have buyers for these lots. So if you make it too onerous that we can't sell the lots, people will just say, I'm not going to take the variance. So we're trying to give them a toolkit, if you will, to do this. The same question came up when we were before the Planning Commission and the board, but mostly the Planning Commission. Will you agree to a covenant to save the estate house? Because you're saying that's why you want the waiver. And we said, we're going to save it, but we can't agree to that covenant. And they understood that because we have to sell this. There may be tax deductions that can be had for conservation easements. So if you make, I know what you're trying to do. It's a good thing, and we agree with the logic. We're here because we want to save the trees. But if you make it too onerous, and I'm not suggesting you're trying to make it onerous, but if you make it so that we feel that we can't sell the lots, they'll just have to say, we'll just go with the blue line because that'll give people the flexibility. So,
Look, to quote a famous law professor from the University of Chicago who's long dead on a totally different subject, sometimes you put your head into the mouth of a lion and hope it will be a kind and gentle lion. So, I mean, there's no doubt that we're not going to do any great harm in giving you this relief to allow you and your subsequent owners to move the houses up toward the street. But we don't know that we're going to get the benefit that's the basis for granting the relief, and you're asking for the relief in the first place. So we're enabling you to do it. We're enabling the lot owners to do this thing, should they be so inclined. But we're really not being assured that the problem will be solved by doing it. We're just enabling it to be solved. We're giving you an option to do this, and the future people an option to do this that they don't now have. But it doesn't necessarily save any trees that wouldn't be otherwise saved by the process of the Shade Tree Commission.
Well, it does with regards
That's what the conservation
Well, that's a condition of your subdivision.
No, actually,
So
the one in the back, the one along Newtown Road, is tied to whatever zoning relief we give, and this assumes we give them the full zoning relief. In other words, you take the gap all the way around the cul-de-sac between blue and yellow and take the square footage, and that's the easement in the back. That's the only firm thing that we get out of this.
And it's area for area, like a wetlands mitigation. You're basically saying,
Yes.
give us this and we'll give you that.
But who's going to knock that down
Chandler.
anyhow? If I were to buy one of these houses, there's no way I'm taking that vegetation down so that my house is backing up to Newtown Road at 5 o'clock.
Well, that's a real steep area anyway.
Yeah, I mean, they're not doing anything.
Yeah.
So we're, I guess my question that I was going to ask you is why? I mean, what difference have you at the blue line? I mean, I don't understand. I don't understand why you're asking for the yellow line as opposed to the
I
blue
think
line.
what he's saying is this. Let's say, let's look at lot 3, okay? If the guy has to build back beyond the blue line and he wants to put a tennis court and a swimming pool, he's going to have to bump up against the trees and maybe lose some if he's allowed to. Whereas if he's up at the yellow line, he can fit more stuff in his yard before he ever hits the trees. I mean, that's what they're saying, basically. You're giving the people the ability to use their land the way they want to, with less likely to have a conflict between man and nature.
It's an encouragement. It's not a guarantee.
That's right. It just enables them to do it. It gives them the ability, the tools to do it, but it really doesn't guarantee that it's going to come out that way.
The only guarantee, because you already have whatever tree regulation we have in Radnor Township, the only guarantee is you get the area conservation easement along Newtown Road. That's the trade, and plus a legitimately encouraging
and nobody's
mechanism.
going to build there anyhow. I mean, they're not going to take those. They're not going to take that down.
No, I'm just saying that's what it comes down to. The guarantee
Well, it's
is-
smart. Give up something that someone else wants that you don't care about. So it's the perfect trade-off from everybody's perspective. I mean, I have no objection to that. It's good for the township. It's good for the community that we have that buffer there. And they don't mind giving it up because they're really not going to do anything with it anyway. There's nothing wrong with that.
We met with the Planning Commission even before we filed the plan to get feedback from them if they would support the waiver for the road right-of-way width. And they were the ones who suggested, yes, we support the road right-of-way width. We would also like you to consider asking for a front yard setback variance. That was not our idea originally. We've spent a lot of time and money pursuing it. Our choice, we're not complaining about that, but this was something that was asked of us to do. We worked very hard with the Planning Commission and the commissioners to agree to number 3, and number 4. It's not a condition, but there's also a good chance that this whole area over here on the other side of Sproul Road may be donated by our clients for a
It's all
conservation
floodplain
easement.
anyway, isn't it?
It's a lot of
Yeah.
floodplain, but that could be a separate lot. It's separated by a road, and somebody could come and ask for a variance to do something there. But that may be, they're looking into donating a conservation easement on that, and the township has asked for some rights to do some things in there that we've agreed to. So, I think it's a good plan. You can say that nobody would cut the trees down. A lot of people have said that and found that it isn't so. And, the Planning Commission and the Board of Commissioners felt comfortable, doing that. So, and we were comfortable
Yeah.
with it as well.
I mean, it's its own little screen neighborhood. So I don't think anybody outside the street is going to really much care about this. And if it enables them to do the right thing, let's hope that they do it. And meanwhile, we're getting the easement. So,
And there's about 150 trees in these easements that we've actually had surveyed that will be absolutely preserved.
is your case closed, George, on this?
Yes, I'd like to move all my exhibits into the record, and that's all I have at the moment.
Well, I'd like to move that the relief be granted.
Oh, wait.
What?
Yet.
We have to have the public comment.
You can public
Oh.
comment. Oh, when you're okay with it, we're doing it, huh? So, is that the way this works? Now you're nice. Before you're not so nice. Is there any public comment? No. Okay. Any discussion?
Not nice or not nice. It's dispassionate application of the law.
Listen, I understand. It's to get rid of that extra.
Love
energy
Nick
you have.
Keneally every bit as much as I love George Brosman. However much that may be, George.
Any discussion?
I didn't know how to respond to that, so I didn't say anything.
Did you close and move that your?
I did,
material
and
be-
asked that my exhibits be entered into the record.
Any discussion? None? All right, now, Noah, what would you like? You can do this one, Noah.
I recapitulate my earlier motion. That I vote that we approve the relief as granted to allow the reduced side yard in accordance with the request of the
Front yard.
of the
Front yard.
front yard, but in accordance with the request of the applicant and the plan that is before is labeled A13.
Peter, you can go second?
I second.
I agree.
I agree also. All right, we going on to the next one now?
Yes, let me just change.
You going to change streams here?
Notebooks.
Okay.
Yeah. Just give me a really quick chance to. Mr. Chairman, could we have just 2 minutes while I write a couple of notes down?
All right,
2 minutes.
you're on.
Run the clock.
2 minutes. Do you have a big plan from the last hearing, so I can put it in the file instead of just a little one?
Yeah.
Or is that 813? Yes.
Joe, could you take 813?
Done.
Thank you.
While we're on a little break, is it okay if I hand out?
Mr. Rosen, maybe we should go through some exhibit numbering before we proceed.
Okay.
I was going to put the application as A1A. The addendum to the application as A1B.
Okay.
Your Exhibit A, the agreement of sale, as A1C.
Sure.
The deed, Exhibit D, is A1D. Exhibit C, which is a bunch of photographs, would be A1E. And then this this grading and utilities plan, which is labeled Exhibit D, I guess that would become, what did I just do? No, there's a different, A1E. Exhibit D, which is, this is just a bigger Exhibit D, this would be A1F.
Now, while we were taking notes, Mr. Ryan, I handed up A2 through A5, which I can identify as we go through.
Okay. I'd like to also ask, since you refer to it in your addendum and application, that I distribute to the board and, enter into the record a copy of the Chapter 175, the grading and excavation ordinance, which I took off the internet today. Is that all right?
That's fine. In fact, I had some extra copies of that in case the board asked.
Yeah, why don't we just make that ZHB1?
Okay.
Okay. Okay. All right. Is this the law A13 from the prior hearing? Yeah, you get that. Yeah, you get that.
That's from this hearing.
Yeah, okay.
That's from the first hearing. That's for the
Yeah, that's for the front.
Here's a copy of ZHB1. Yeah. Gentlemen, here's a copy of the grading ordinance. If anybody wants it, that would be ZHB1.
I'll put that one in the folder.
Yeah, there's copies for everybody.
Thanks.
You and Marcus, what do you call it?
ZHB 1.
That's A6. That's the steep slope ordinance, which is different from the grading ordinance.
Yeah, mine's marked A6.
The A6 is just from our code book.
Yeah, it's just for
Yeah.
convenience. I just thought it'd be easier for the board, but we don't even have to admit it because it's right out of the code. Right. We have a big one of A3, which is the existing conditions plan. But that's correct, Mr. Falcone. We're going to give it to you when we're done.
Well, Mr. Brosman, I will confess that having looked at your application, I have real difficulty with a blanket interpretation that man-made steep slopes are outside of the steep slope ordinance. I understand your arguments, tying it to the grading ordinance and so forth, but they're simply on the face of the steep slope ordinance. There isn't a qualifier as to how the slopes got there, and I am concerned, candidly, about a broad brush application because it would pick up all man-made steep slopes, no matter how old they were, how big they were, how intrusive they were, and I think there's a good. The purpose of the steep slope ordinance is to protect against erosion. So, just a fair as to the variance piece, make your case and pursue the other as well. But I'm not with you on that one.
Okay, well, I appreciate that. That wasn't going to be our focus anyway. That was an alternative argument. Our witness is going to focus on the other measure of relief. I may make a few comments about the man-made argument if it seems like I need to.
Well, I mean, you're free to make it, and you may want to put it into the record.
Sure.
But I don't think a reviewing court, if we were to decline to interpret the code that way, would have too much difficulty with us.
Is the approved plan? Is this an approved plan? The one you just handed out here, A4. Is this based upon the approved subdivision plan? In other words, how do you know where you want the relief exactly? Is it based upon something that's already been worked out? But I mean, if this isn't an approved plan, what if you wind up changing it in the approval process and then you need relief somewhere else and not here? In other words, is this where we know we need relief for sure and only here?
Yeah, is that plan, is that based on our preliminary plan approval?
Okay. Okay, I'd like that to be on the record to say that that is. So I wouldn't want to consider relief now and find out we need other relief.
All right, Mr. Brosman, you're on.
Good evening again. For the record, George Brosman representing the applicant. We're here with regard to the property at 615 Newtown Road that you've just addressed in the other matter, so you're very familiar with this property. What we're here for in this application is that, and Mr. Gibbons is our engineer, he'll be testifying. We've reviewed the site and we found certain man-made slope areas that really should be disturbed and removed and regraded. We had met with Mr. Kachansky about these areas. I think he had even been out to the site. I was not there with him, but he had seen these areas. So he made certain interpretations and felt it best that we come to the zoning board about this. So I'm just going to have Mr. Gibbons identify the areas in question and tell you about them and why we're seeking the relief. So could I have Mr. Gibbons sworn in, please?
Raise your right hand. Do you promise or affirm to tell the truth, the whole truth, nothing but the truth? And state your name for the record, please. Say it for me.
David Gibbons.
And it's Gibbons for the record. Dave, could you very briefly
Does everyone agree that they read his bio to accept him as an expert witness?
Yeah, I'm offering him,
They don't
he's a
object,
civil
no.
engineer, as shown on A2. I'm offering him as an expert in civil engineering.
Okay. Any questions? No? All right.
Dave has the plans for the proposed subdivision of 615 Newtown Road that received preliminary approval from Radnor Township. Have you prepared those plans?
I have.
And are you familiar with the subject property?
I am.
Now, I placed on the table here what we've marked Exhibit A3. Is this an existing conditions plan sheet from the preliminary plan set?
It is.
And it's, for the record, dated August 20, 2012.
That's correct.
And just for the record, identify this property briefly.
Sure. It's a existing 13.6 acre tract located in the R1 zoning district. It's currently a developed property that consists of an estate home, a garage, a second dwelling, and a fairly extensive driveway system that loops back out onto Newtown Road through the
And
property.
as I mentioned, we're here this evening to discuss certain steep slope areas on the property. By way of background, under the Radnor Township zoning ordinance, what slope of land is classified as a steep slope?
It's a 20% or greater slope.
And as part of your work on this matter, did you identify those areas on the property?
I have.
And are some of those areas with a slope of 20% or more natural steep slope areas?
Yes.
And are some areas, in your opinion, man-made steep slope areas?
Yes.
And by way of reference on Exhibit A3, how have you identified the slopes, generally the natural ones and the man-made ones that we're here seeking relief about?
In reference to Exhibit A3, the areas that we are seeking relief from have been shaded in red and also labeled as A, B, and C.
And the other slopes are shown in a gray shading?
Yes, that's correct.
Are the red shadings on Exhibit A3 the same as the yellow shadings on Exhibit A4?
Yes.
So A4 is the same as A3 with different colors?
Right. A3 was meant to show you in case you wanted to see what does it look like on existing conditions, and A4 was an attempt to say where would these be under your proposed plan.
Where's A3?
A3 is up here
It's
on
up
the
there.
board.
Oh, so you didn't distribute those. Okay.
Yeah.
No, we don't have it.
It's just,
A4 is exactly A3, but they're using red and ours is yellow.
Well, actually, it's the same locations, but A4 also shows the approximate proposed homes, whereas A3 is existing conditions. It doesn't show the homes.
A3, Dave, maybe you could, and I apologize, we didn't have extra smaller copies. Dave, can you just describe where the driveway is, because that relates to the man-made slopes, and point out where the estate house is? So A3, again, is the existing conditions with the slopes overlaid on that.
Sure. A3 shows the existing driveway coming down from about the center of the exhibit from the north, heading down to the southwest to the estate home. It then makes about a 90-degree angle turn to the west and heads over to the existing barn structure, which is located on the western side of the property, and then continues west past the barn, makes another about 90-degree angle to the north, and heads back out to Newtown Road.
And your testimony, we'll get to it, but it obviously shows the bulk of the man-made slopes in question located along that extensive driveway system.
Yes, it is.
Now, this old estate goes back well over a century. Was the driveway system and the improvements on the lot created, probably that long ago, certainly before the township zoning ordinance and the grading ordinance?
Yes, I believe so.
Now, I've handed out Exhibit A4. We'll put a bigger one up here. Is this a plan, as we've said, that takes the proposed preliminary subdivision plan and tries to show these same slope areas on this plan?
Yes.
And can you, and you may decide to refer to both plans, but do so as you see appropriate, but explain to the board the three general areas of man-made slopes that we're talking about.
Yes, Area A, the slopes are located on either side of the existing drive, east and west.
And for the record, we're talking about the areas highlighted in yellow. Those are the areas we're seeking relief to disturb, correct?
That's correct.
Okay, go ahead.
Area A consists of 3,233 square feet. Believe it's a man-made steep slope, as it's on either side of the existing drive, and were created when the drive was cut in, and the embankments were created on either side.
And there's a photograph on Exhibit A4. Is this a representative photograph of the driveway in the area of Area A there on Exhibit A4?
Yes, it is.
And could you highlight to the board what you're talking about, where the slopes are in that photograph?
Sure. In the photograph, you can see that both the right and left side of the driveway is slightly banked. The western side, or the right-hand side of the photograph, is slightly more steep than the left-hand side.
So it's pretty clear from the existing condition plan and the photograph that these are man-made slopes?
Yes, it is.
And what do you propose to do in this area?
We're proposing to remove the existing driveway and grade through that area with a much more uniform slope.
Will the
Excuse me, ma'am, if I might interject here. Are you going to fill in that area or cut on either side and pull the dirt towards the middle?
Primarily, it'll be a little bit more of a filling activity, yes.
Oh, so you bring in dirt from outside?
Not dirt from outside, but it'll probably some other fill from the rest of the site.
Are you going to bury the road or just take up the asphalt?
Excuse me?
Are you going to take up the macadam as well?
The plan would be to, yes, remove the pavement.
So you're not actually disturbing this, I mean, if you're just filling in the road bed, so to speak, then are you really disturbing the slopes at all? I guess you're changing them.
We had this discussion with the zoning officer, and that was an argument that we made, that we're kind of filling, and are we really disturbing them? And I don't want to speak for Kevin, he can speak for himself, but I think he just felt it prudent that we come before you. I'm sure there will be some disturbance. I don't know if we can guarantee that it will be just only filling, but that's the general program.
You're going to generally even out the slope from the right side of that photo to the left side so that more or less they will become even, correct?
Correct.
Will the trees be disturbed?
Yeah, they're going to remove them.
There's a notation on the plan of
1,
existing
2, 3,
hazardous
4,
trees.
5, 6, 7, 8, 9, 10, 11, 12, 13 trees along that road, right?
Is the tree issue before us? That's not our issue, is it?
No, I don't believe so. In fact, what we were going to, and I can ask Mr. Gibbons and Kevin can chime in, but when we met with Kevin, we've had, as part of the Shade Tree Commission process, we have landscape architects, Joe Orsatti and Pat Stewart, who are here. They've also have a certified arborist who have looked at these trees on the site, and they've determined that these ones shown in red are hazardous and should be removed, whether we do our project or not. So the reason we showed them on here, one, was to let you know, but two, we had the discussion with Kevin was, you know, we would have to remove these trees anyway, and to remove them properly and grind up the stumps, we would disturb a good portion of those slopes anyway. I don't think he had an issue with that, but we couldn't show that we would disturb all of the slopes by doing that. So we would disturb a lot of them, but not all of them, so we just came in for relief to cover the whole area.
You're not asking for a specific element of relief as to trees. You're just simply looking for disturbance of slope. So if there's regulation that applies to the trees, that's not in front of us right now.
That's right. We'll deal with the tree regulations and the Shade Tree Commission. We're not asking for relief from that. From you, just the steep slopes.
Mr. Gibbons, excuse me, has the township engineer reviewed your intended regrading?
No, he is not.
What we're going to do, so you know, Mr. Cutler, I think we've discussed this with Kevin. We just got our preliminary approval. We did not show the disturbance of the slopes on that plan, except in the area of the roadway, which we have a determination from the engineer we're allowed to disturb those. If we get the relief, we will show it on our final plan, and it will be reviewed then by the township engineer for conformance with all of the grading and sedimentation and erosion control measures. But we needed to know whether we would have permission from a zoning point of view to disturb them, and then we would show them on the on the plan.
You're not looking for relief from the grading ordinance, so we could
No.
accept, if the board grants relief, we could specifically exclude, any approvals under that ordinance, because it's not our ordinance to administer.
That's right. We're just here because we had to deal with the zoning ordinance piece of this.
I just wanted to make it clear that in Section 112, the slope control section of the zoning code, it lists 5 enumerated intentions of having this section. So we would be concerned that the township engineer, who I think is the only one really qualified on our team to pass on these things, be satisfied as to all these issues. I mean, we don't have the expertise to review this, even if you had the details to give us.
Well, Mr. Cutler, we could put
Yeah.
specifically into an
That's what
approval.
I'm getting at, yeah.
If you wanted,
Yeah.
that they've got to make the township engineer happy under this approval, in addition to complying with the grading ordinance and any other, shade tree and applicable requirements.
I'm thinking of ourselves as doctors. Our first rule is do no harm. So he'll be our protector as to doing no harm in what you want to do.
Right. I think that makes sense, and I was going to have Mr. Gibbons testify that he believes we satisfy those intents as well.
But we could put, those would be conditions to an approval that would not,
Sure.
that would be accepted by the applicant.
Sure. Dave, let's move on to Area B. And kind of like you took us through for Area A, take us through for Area B.
Sure. Area B is located on the northern side of the existing dwelling. As the driveway heads south and then makes a turn to the west, it runs in front of the existing dwelling to the driveway on the western side. Similar to the construction of the drive in Area A, as the driveway was installed in Area B, there were slight areas of cut created on the northern side, which resulted in a few small areas of steep slopes.
And that, there's a photograph, it's sort of hard to see because it's frankly so small. There's a photograph of that general area on Exhibit A4.
Yes, there is.
Mr. Gibbons, is my reading of this exhibit correct, that the height of that cut is about 2 feet?
I would say approximately it is, yes.
Yeah, okay.
And what will you do generally in that area?
Generally, as a new driveway has to be brought into the existing dwelling, since we're removing the existing drive, that general grading of the stormwater management structure and the driveway in the front yard of Lot 7 would just regrade those areas to a more flat, normal-looking front yard.
And again, that, like we said before, that would be shown on the final subdivision plan submitted to the commissioners.
That's correct.
Now let's move on to...
Would that be, I'm sorry to interrupt you, George, would that be accomplished by that filling as well, as opposed to cutting?
That would probably be cut.
Okay.
Yes.
Let's move on to Area C. I don't know which plan you want to refer to. This area is obviously a little different. It's not associated with the driveways.
Sure. Area C, in reference to Exhibit A4, is located to the rear of the dwelling, the proposed dwelling on Lot 3. Consists of approximately 673 square feet of steep slopes.
And you've been out to the site and seen this area?
I have.
How would you describe it to the board, and why do you say it's man-made?
Sure. It doesn't look quite like it on the existing conditions plan from the contours, but in visiting the site, there is, from what I believe, was a graded, terraced, rectangular, flat area. I'm assuming it was for possibly a pool or a play court, but it's almost perfectly rectangular in shape, and was graded in a typical form of construction where the back edge or northern side was slightly cut into the hillside, and then that dirt was utilized to then fill the southern side to make that flat area.
And the Part C on this exhibit, is that the cut area you're speaking of, or the fill area?
That's the cut area.
So that would be the back area, the terrace that was created?
Correct.
Now, with regard to this area, what do you envision happening here?
That area would be regraded slightly to provide proper and adequate drainage around the home and actually away from the home. And so it would just be consisting of some minor grading activities.
Now, just for the board's convenience, Exhibit A5, is this a chart that summarizes the three areas that you've just spoken about?
It is.
And can you just run through, it's on the plan, but just run through the size of each of the three areas in square feet?
Sure. Area A consists of approximately 3,233 square feet.
Now, what percent of the total tract area is that?
It is approximately 0.55% of the total tract area.
So that's 0.55 of 1%?
Yes.
And how about B?
B consists of 578 square feet and is approximately 0.1% of the total tract area.
And how about C?
I have a question.
Oh, sure.
When Jim asked you whether you're going to fill or cut, I thought you said you were going to fill and not cut, or do a minimal amount of cutting. Here it doesn't. Here it kind of says you're going to cut.
On A, in Area A.
That description is what it is today?
Yeah.
It's saying what made it man-made.
Okay, so this isn't what you're going to do. This is the
Yeah, so
existing.
the existing area was cut.
Okay.
Yes. Area C is 673 square feet and is approximately 0.11% of the total tract area.
And so what does it total up to?
4,484, and it is 0.76% of the total tract area.
Now, that's a very de minimis number, but in Area A, I think I mentioned, but for the record, that 3233, that includes this area in the road that was already approved for disturbance by the township engineer under the slope ordinance?
It does.
So actually, the number that we'd be getting relief for is actually less than that?
It is.
And do you have a general estimate if we were allowed to remove the trees in Area A and the disturbance, what's the rough amount covered in those red circles?
We've calculated to be approximately 2,177 square feet.
So that would leave a little around 1,000 or less left of A.
Yes, give or take, yes.
Now, are any of these areas, I mean, you've testified about this, but there are natural slopes on the property. Do any of these areas relate to or connect to the natural slopes that are on the property?
No, I believe they're separate.
And you're familiar with the slope control ordinance? It's 280-112 of the zoning ordinance?
I am.
And are you familiar with the intention of those provisions?
Yes.
And the grading that you're proposing, well, first of all, the disturbance that you're proposing of these man-made areas, as we've shown them and described here, do you feel that that runs afoul of those intention provisions?
I don't believe so, no.
And what you'll propose to do as far as regrading on the final subdivision plan, will that be consistent with those intentions?
Yes.
And just for the record, you'll be required to do stabilization and erosion and sedimentation control, things
Definitely.
of that nature?
Yes.
In your professional opinion, will the proposed disturbance and regrading of these small isolated bands of man-made slope have any detrimental impact on any neighboring property or the public health, safety, and welfare?
No, I don't believe so.
That's all I have for Mr. Gibbons. I have a few words that I was going to say about my man-made slope argument that Mr. Ryan didn't like. But I could just do that on my own. I don't think I need a witness for that.
Any questions for no, Peter, Jim?
No.
Why don't we do this? Why don't we discuss and take a vote on whether we would grant the variance? And then if we don't grant the variance, then he can make his argument, his legal argument on the other issue. That way he may never have to make that argument.
Well, yeah, I agree, but I want to see if anybody in the audience has anything to add or subtract from anyone? Okay, we don't.
Before we go into discussion, just you have agreed that this if relief is granted, it would be the grading would be subject to the approval of the township engineer as part of the grant, in addition to whatever approvals in favor of by the township engineer are required under the subdivision land development ordinance or the grading ordinance. So it would be an independent right of approval. And also, we're only talking about the steep slope ordinance, and we're not giving you any implicit approvals under Saldo, Shade Tree, or anything of the sort. It's just limited to that. I believe you accepted all that on the record.
Yes, I agree with that.
Okay. Any other questions? Okay.
I guess I should move my exhibits
Yes.
into the record.
Okay. Any discussion at all for anyone?
I mean, the purpose of the ordinance is stated. We don't want to frustrate that purpose. So as long as the township engineer is going to specifically consider those 5 things and not approve it unless he's satisfied with those, I think we've adequately protected the community.
Right. The only thing I would add,
Issues.
the fact that any existing macadam needs to be replaced, removed. It just can't pile up on top of it.
And whatever's underway.
Well, isn't that something that the engineer will consider?
Well, yeah, I
That'll
would
affect
just-
runoff, it'll affect a lot of things.
You would think, but
Yeah.
it may come up that they're going to put so much that it's not going to affect.
Now, how do we make sure that the engineer, in addition to considering the normal things he does under a grading permit approval, specifically takes into account these 5 enumerated items?
We put it in the order.
But how will he know that? We'll have to give him notice that.
I tell you, he must, it must be subject to the approval of the township engineer in all respects, including with respect to all criteria listed in the grading ordinance. I was going to, not
In the
limit it
steep
to
slope
that.
ordinance, yeah.
Steep
Yeah.
slope ordinance.
Yeah, and this thing is so small. No, and as Jim said, it's almost de minimis. I mean, what they're asking for. By the time you do the trees and everything else, and they have to kind of get rid of that driveway coming in from the other side. I think that's almost a necessity to do, since they're bringing in from the other way, and it's not going to go through, so.
And it never hurts to get rid of impervious
paving
paving anyway. So.
Huh?
And it never hurts to get rid of impervious paving,
Yeah,
so.
it's so, I think there's enough here that it really isn't even, an issue, I think. Okay? Should we vote? I think we should grant the variance under section 280-112D to allow the regrading. The stipulations that Mr. Ryan had put in it, the fact that the engineer must approve it, and also I would like to just kind of put in to make sure that any macadam that's being removed needs to be removed and not just piled up on. Okay. Jim?
I would agree, in particular with respect to the limitations that you put on there, Charlie. I also wanted to say that, from my perspective, under the facts presented in this case, I believe that the relief requested was fairly de minimis, and I'm in favor of the variance.
I agree. Peter? Noah?
I agree, as long as we enumerate these additional conditions in the ordinance, yeah.
Bradley, since you can, we'll let you vote.
I am definitely in agreement.
Okay.
I agree with that.
Done.
Thank you.
Thank you.
Good night.
Good night. No further business in front of the board. It adjourns. See everyone in December.